Hello, everyone. Good morning. I hope you can all hear me. I'm just going to check with marketing team that everyone has been allowed in now. Is that the case, Dom?
Hi, Andy. Yes, I can see people joining. We've got just over 90 at the moment.
Okay, super. Well, look, thank you everyone that's joined already. What we're going to do is we will get underway. I suspect we may have a few more people joining as we go along, but I think we'll kick off and get going. So, welcome everybody. My name is Andy Whitaker. I'm a partner in the employment team at Boyce Turner, and I have been asked to come and speak to you all today as part of our series of webinars for in-house lawyers. Talking specifically about recent employment law changes. So both those that have been introduced prior to the change of government, so legislation that was passed and has either recently come into force or that is going to come into force in the next couple of months. But then in addition to that, looking at some of the proposals that we've seen from the new Labour government, either outlined in white papers in their manifesto prior to the election, or what we've had highlighted in the King's speech a couple of months ago. A bit of a disclaimer, I suppose, though, to start with. We know a general direction of travel in respect of a lot of this new legislation because we've had the intentions of the government set out and also guidance provided with the King's speech as well. But we're still waiting on quite a significant amount of detail in respect of a number of the pieces of legislation that have been put forward. We anticipate to receive further details within the next few weeks. A lot of these pieces of legislation or the issues associated with the legislation are earmarked as being dealt with or implemented within the first 100 days of the government. That deadline comes up in the middle of October. So hopefully we should in the next few weeks get a bit more meat on the bone as far as the proposals are concerned. But we can talk today about general direction of travel and also what we need to be thinking about as in-house lawyers to prepare ourselves for the new legislation when it comes into force. So for those of you that do not know us, we're Boyce Turner. We're a commercial law firm based in Reading in the Thames Valley, and we support businesses both in the Thames Valley and across the UK, EU and globally as well. I'm the head of the employment team here at the firm, and we provide support on HR matters, litigation, business immigration, as well as training and coaching to our clients as well. So should you have any questions or queries following the webinar today, then please do reach out to us. We'll be more than willing to help. I will also be providing a copy of these slides by PDF after the event. Our marketing team will send that out to you. So you will have those. There should also be an ability for you to ask questions as we go along too, depending on, so just use the Q&A function in the Zoom panel. We will see how we do for time, basically, to see whether we can pick those up. If there are some questions that come in as we go along, I will see if I can pick them up at the end. Alternatively, if I don't have the opportunity to do so, I will, of course, come back to you separately and provide you with the answers to the questions that may be asked. Okay, so moving on from there, what are we going to be talking about today? So the particular topics that we're going to cover, to begin with, we're going to speak a little bit about fire and rehire and the way that the rules around that have changed recently, but may change again under the new government. We're going to be talking too about the changes to the rules and the laws around sexual harassment in the workplace and some additional obligations that fall on employers as from October of this year. We're then going to be talking about Labour's key proposals. So we're going to be looking at the proposed employment bill and what might be included in there. There's several substantial changes that have been highlighted, and it's worth speaking about those in a bit more detail. We're also going to be talking about the Equality, Race and Disability Bill as well, which will have an impact potentially on larger employers in respect of pay reporting. So we already have obligations around equal pay reporting, but there may be some new obligations around reporting on race and also disability. And then we'll have a bit of a summary at the end around some takeaways and some next steps. I'd just say to begin with, however, that we have, if any of you have experience and have requirements to work in the employment field, had a relatively stable and steady regime that we worked under for a considerable period of time. I first entered the legal profession in the late 90s, early noughties, and there have been changes. So we have seen, for example, the extension of discrimination rights to cover a wider variety of protected characteristics. We've also seen new legislation around, for example, modern slavery and equal pay gap reporting that I've mentioned already. But fundamentally, the key principles around unfair dismissal and discrimination haven't really changed very much in that 20-year period. But if you take 20 years back from 2000 to take yourself back to 1980, that was an entirely different industrial relations landscape at that time. And it would be almost unrecognizable the way that employment lawyers, or businesses for that matter, needed to engage with their employees in 1980 versus 2000. And I suppose the point that I'm making about this more generally is that there's been a lot of commentators that have spoken about these changes that Labour are proposing as being sort of game-changing and really altering the landscape of the employment law world considerably, whereas others have suggested that maybe they won't represent such big changes as we perhaps anticipate. But the point is that simply because we're used to something operating in the way that it has been for an extended period of time doesn't mean that it'll always be that way. And change does indeed happen. And any of you with experience dealing with employment regimes in other countries, even across EMEA, will know that there are different ways of interacting and engaging with workforces. Any of you who have experience dealing with employees in the Netherlands, for example, you'll be aware of the concept of having to get court approval before you put through a dismissal. Any of you with experience working in Germany or other jurisdictions for that matter will be quite used to having to engage with collective bargaining agreements, sectoral ones perhaps, and in Italy, CBAs that are based around seniority too. So there's a number of different ways in which employers and employees are required to engage across EMEA. And so it's not to say that the way that we do things currently is necessarily the best or the right way to do it. And it's also not the case that we can expect it being like that forever. But what we can say is that there are a few changes that we already know about, and we'll start off with those. So the first thing that I'm going to talk about today is fire and rehire. Now, I'd like to hope that many of you have got no experience of dealing with fire and rehire, because when I speak to my clients about it, we often talk about it as being a nuclear option. So it's something that we don't want to have to contemplate, and where we do, it's in extreme circumstances, because we're mindful that this can cause us some considerable challenges and industrial relations problems. So what do I actually mean by fire and rehire? Well, it's a concept in the UK where if an employer wishes to alter the contract of employment of an employee or a group of employees, there are limited ways in which you can do it. You might have some mobility, some variation provisions in the contract that allow you to either vary specific clauses or maybe some minor clauses in the contract more generally. But a contract of employment is, of course, supposed to be not supposed to be unilaterally imposed by one party, but a bilateral bargain between the parties. So if you wish to change it, the general rule is you need to get agreement to change it. But what happens if an employee simply refuses to change their contract of employment? How can you push through that change if the employee refuses to consent? Well, the answer to that may be that you could consider terminating the contract of employment that the employee or the employees are currently employed under and offering them new employment to commence the day after their notice expires. That would represent a dismissal. So even if it is the case that the employees accept the new offer that has been made and there is no break in the continuity of their employment, they have nonetheless been dismissed. And that means that an employee can potentially then bring a claim for unfair dismissal against the business, even if it is the case they've accepted the new contract of employment. Now, that may seem like a rather odd thing to do, but don't forget, if someone has been unfairly dismissed, they're entitled to what us employment lawyers refer to as a basic award, which is broadly akin to a a statutory redundancy payment. So if you have a very long-serving employee who is sitting on many years' service and therefore a decent wedge as far as a statutory redundancy payment is concerned, if you are looking to fire and rehire, it may be in the interest of that employee to potentially accept the new contract of employment, but nonetheless conceivably could still bring a claim in the employment tribunal, arguing that even though they've mitigated their losses by accepting the new contract of employment, they've nonetheless been dismissed and unfairly, and therefore they're entitled to receive their basic award for that dismissal. So in what circumstances might we be able to fire and rehire and do it fairly? Well, it would fall within the definition of being a some other substantial reason dismissal, one of the 5 potentially fair reasons to dismiss in the UK. And case law has established over the years that it's not necessary for an employer to demonstrate that it is a business critical decision, that's an existential matter for the business, and that unless they push through this change of contract, there is a crisis awaiting the employer that might result in its administration or failing. But what an employer does need to demonstrate is that it does have a pressing business need, and it's a genuine need. They also need to demonstrate that they have explored all other options, and there's no other options that could potentially achieve the same goal. And they've also gone through a fair process. So they have consulted with the individuals, they've explained to the individuals what the consequences might be, and there has been as much consultation as is necessary to go through the various issues that have arisen in respect of the potential change. Now, fire and rehire has been quite controversial over the last few years. Some of you may remember there was a case involving P&O Cruises back in 2023, where there was a plan to fire and rehire over 900 staff if they didn't accept a new contract of employment. And because of the noise around this particular issue, we did see a new code of practice introduced by the former government, by the Conservatives, that came into force in July of 2024. And this imposes some new obligations upon employees if they are considering going through a fire and rehire process. Now, with all of these codes, it is non-statutory in that it is not, an employer is not obliged to comply with the code in the event that it is going through a hire and rehire. Let's keep getting a fire and rehire process, easy for me to say. But if we fail to comply with that code and a tribunal ultimately finds the dismissals to be unfair, then there is the potential uplift to compensation of up to 25% in respect of the dismissals. So what does the new code require us to do? Well, it requires employers who are facing such a situation to engage in meaningful and early consultation with their employees about it. Emphasis on meaningful. So we do need to go into that with an open mind and with a view to trying to seek an agreed resolution to it. We need to consult with all staff that are affected and or unions if they are recognised. Just a side comment on this around collective consultations that I've got a note at the bottom there around. If we are looking to fire and rehire 30 or more employees, 20 or more employees, then that, because of the way that the definition of redundancy is drafted under the Trade Union and Labour Relations Act, would represent, believe it or not, a redundancy, and therefore would trigger the obligations to collectively consult with the affected employees. So in addition to the necessity to follow what would be a fair process to justify a fair dismissal, there may also be implications if you fail to collectively consult if that requirement is triggered. The consultation also needs to last for as long as possible in order to make it agreement a possibility, even if agreement can't ultimately be reached. It needs to be a last resort rather than something that an employer engages upon without exhausting other options. And it equally can't be used to threaten employees. So we can't put that metaphorical gun to the head of the employees to try and force them into accepting the new terms and conditions that are on offer. Now, having said all of that, we know that the Labour Party takes a much stricter view around fire and rehire. And it's been stated by the new Secretary of State for Business and Trade, Jonathan Reynolds, that although the code is going to remain in place for now, there is an intention to bring forward new legislation which will end the practice of fire and rehire, and a new strengthened code replacing the existing one. So precisely what that means, we don't know as yet. In terms of entirely ending the practice of fire and rehire, well, I mean, there may still be circumstances, extreme circumstances potentially, where an employer does need to try and agree a new set of terms and conditions with its employees for very good reasons. I already identified the fact that as it currently stands, based on existing case law, it's not necessary for an employer to demonstrate an existential threat to their business to be able to justify a dismissal on this basis. But equally, if that were the case, is it really going to be expressly outlawed for a business to enter into this sort of process in order to safeguard the future of the business? And if not, would a business instead be having to make redundancies? And that is not obviously not necessarily in the interest of the employees, nor in the interest of the economy more broadly, if of course we want properly functioning and profitable businesses. So watch this space as far as that is concerned, and we will see what new legislation is produced by the Labour Party and any new draft codes that are produced. For the time being, however, if there is a requirement or a consideration to look to press through any changes to contracts of employment, then do bear in mind the drafting of the new code and the obligations that it imposes. The next piece of legislation that was passed by the old government, but this time is now going to be coming into force in October of this year, is around unwanted conduct of a sexual nature. So it has been the case for many years that, of course, an employee may be held responsible for their conduct in the workplace if they subject an individual to a colleague to an act of discrimination, including sexual harassment. And in addition to that individual being held potentially liable for that conduct, an employer can also be liable for the actions of that individual. There may be an ability for an employer to run what's known as the statutory defence if a claim is made, if they can demonstrate they've taken all reasonable steps to try to avoid that discrimination, that harassment taking place. But notwithstanding those efforts, the individual has still conducted themselves in a discriminatory fashion. That's often quite a difficult test to overcome. We will run it from time to time on behalf of our clients, especially where an individual has conducted particularly egregious behaviour, and certainly incidents of sexual harassment would tend to fall within that, into that example. But as I said, it's often difficult to actually justify or to stand up that defence, often for lack of being able to demonstrate training or appropriate policies having been brought to the attention of the individual who's committed the acts of harassment. But what we're talking about here is not an adjustment to those provisions, but actually the introduction to a new positive and proactive duty on employers to take preventative steps to avoid the harassment taking place in the to begin with. So this isn't about enabling an employer to run the defence. We did everything that we could to stop it. What this is an ability for an individual who's pursuing a claim to say that not only did the employer fail to take preventative steps and therefore they should be held liable for the actions of the employee, but in addition, that failure in itself also gives rise to an additional level of liability on behalf of the employer, excuse me. So it's not an additional, it's not a standalone claim. So what you can't have is an individual who looks at the training that's provided by their employer and say, well, I think this is deficient and lacking, and I don't think my employer is doing all that can be done to prevent sexual harassment taking place in the workforce, and therefore I wish to bring a claim against my employer for doing that. It is only when there has been an act of sexual harassment in that, and they bring a claim about it, they're then allowed to add this on as an additional claim that they can then pursue against the employer. The question therefore arises, well, what do reasonable steps look like? Well, it's going to depend, as is often the case with employment law, on the size of the organisation concerned, perhaps the sector that they're working on, and the working environment. So I've already mentioned about it not being a standalone claim, but what we can see is that there can be an increase in compensation that's awarded of up to 25% if the employer fails to demonstrate that it took those reasonable steps. And we also are going to see, in addition to this, some new powers for the EHRC in terms of injunctions, investigations, and also potential naming and shaming of employers that are found to be liable in such circumstances. So these reasonable steps then, what might they look like? What this is not is a statutory requirement for employers to put sexual harassment, anti-sexual harassment training, making that an obligatory and mandatory step. That is the case in a couple of jurisdictions around Europe, for example, but that is not what we have here. So an employer is not going to be found automatically liable simply because they don't have a training program in place. It is up to employers to work out, bearing in mind, as I said before, their size, the resources available, the particular working environments that they may have, to identify what is most appropriate for them. Clearly, training would be a good way of addressing some of those concerns, but it's not the only thing. I'm certainly advising businesses to consider carrying out audits at this time to sort of identify where there could be, well, first of all, identifying what policies and processes that we have in place already, what training has been provided, what additional training should we be looking to provide, but also thinking about risk assessments too. Have we got particular areas or circumstances where we consider there might be a greater risk of acts of sexual harassment taking place, whether that be because of the shape of teams, whether it be reporting lines, whether it be social events, for example, but identifying where we think there could be potential challenges. Employers also clearly should deal with claims or complaints when they are made, not least because it's the right thing to do, but clearly if you have a report made to you and it is investigated, and if it is upheld, there are consequences for the individual concerned, the individual who is found to be the perpetrator of the acts, then that's something that you can potentially rely upon at a later date, not necessarily in respect of that particular claim, if a claim emanates from it, but to be able to demonstrate that you are taking reasonable steps, because when these complaints are made, they are investigated, there are consequences, and people are aware of it. I've already mentioned training. Clearly, I think it is an important step to take. And we also need to think about who is being trained on this. I often spend a lot of my time speaking to HR managers and talking about this sort of thing, and they sit there furiously agreeing with everything that I have to say, which is great that we're on the same wavelength and on the same page. But of course, the point is that we need the business more widely to understand their obligations and their duties as far as this is concerned. So just advising a few people maybe at board level, or making just ensuring that HR or legal are aware of it, won't necessarily go as far as is necessary to demonstrate that those reasonable steps have been taken. So anyway, that is something that is coming into force in October of this year, and I wholeheartedly advise you, if steps have not already been taken in this regard, to carry out those audits to understand what you're doing in terms of training, risk assessments, policies, etc. are concerned. That is something that you should be doing in advance of the introduction of this new legislation. So moving on to the employment bill, the mooted employment bill, and what we might see introduced by the new government, either within the first 100 days or shortly thereafter. Now, it's fair to say that there has been a slight waxing and waning of proposals that have been made by the Labour Party, first in terms of their white paper that was published probably getting on for a couple of years ago, if not 18 months ago, around proposed changes to employment law. That has obviously been that was drafted in consultation with the trade unions. There was then much debate about how much of that would be retained within the manifesto when that was published pre-election. And then subsequently, of course, we've then had the King's speech back on the 17th of July, where some specific key policies were set out. But even with the guidance notes that were provided with the King's speech, what we've got are some key principles and some intentions, but without necessarily the details sat behind it. And those details, as ever, is going to be where the devil is found. And so we can look at what the proposals, broadly speaking, look like, but it's at the moment, it's quite challenging to know exactly what we should be doing to address them until we get those draft regulations produced. So picking up on the first crucial point, and that is around unfair dismissal. Now, as many of you know, if you have any practice in employment law at all, in order to bring a claim for unfair dismissal in the Employment Tribunal in the UK, for an ordinary unfair dismissal claim, that is, it is necessary for an individual to have 2 years service. Now, that 2 years qualifying service is a figure that has waxed and waned. It's gone up, it's gone down over the years. In fact, if you track changes of government and then you plot a line as far as the service requirement to bring an unfair dismissal is concerned on a graph, you'll see that it goes up and down pretty much every time there is a change of government. But what we have seen proposed by the new government is the right not to be unfairly dismissed becoming a day one right, and therefore that being something that all employees from the commencement of their employment acquire protection from. They cannot be unfairly dismissed within that period. Now that poses a challenge for businesses because as it stands at the moment, we have a fair degree of leeway within that first 2 years. But if we take a view that actually something is just not working out, then we can take a decision to terminate the individual's employment, notwithstanding the normal expectations to go through potentially an exhaustive performance management process, or even in some circumstances going through any sort of disciplinary process where we're talking about acts of misconduct. Such processes can take some time. They also can be stymied by individuals perhaps getting themselves signed off sick. And when we're dealing with people with extended periods of service that take them over the 2 years, the termination of an employee can be a long and drawn out process from time to time. So at the moment, we have this 2-year safety valve. However, removing that entirely and requiring employees to have protection from unfair dismissal right from the outset will focus the mind of businesses in terms of a necessity to look at our processes. But I think actually to really focus on the issue of probation. And that's not least because although the government has said that they are intending to introduce this as a day one right, they're also saying that that's going to be subject to an appropriate probation period. So what does that mean? Well, as I said, the devil is in the detail. We're not quite sure what it means at the moment. Might it be, for example, that we're talking about an employer's ability to dismiss being curtailed or at least fettered right from day one, but there being separate processes that apply during a designated period of probation, perhaps, let's say, maybe for the first 6 months of employment. So not necessarily giving the employer carte blanche to simply hire and fire at will within that 6-month period, but perhaps the normal rules around unfair dismissal being altered and changed within that probationary period. So there's still an expectation of a degree of fairness, but the employer still having a greater degree of flexibility than might otherwise be the case once we get out of that period and the employee gains protection from unfair dismissal in full. I think the issue of probation and onboarding more broadly is something that businesses do need to think about in more detail, notwithstanding this potential change in law, because as many of you will know and appreciate and have experience of, recruitment can be challenging. It's not always easy to get someone in. There might be a real race for talent and it being difficult to find an ideal candidate for your role. And then when you get them in role, you want to give yourself every opportunity for that to be successful. It's, as I've already mentioned, a time-consuming process. It can also be quite expensive with agency fees that are incurred in trying to find that candidate. So we want that recruitment to be successful, and we want to give ourselves every chance of that being the case. So I think a real focus on probation and onboarding is really crucial, not just because it looks like we're going to have some additional obligations laid upon employers as far as how they conduct that process and the fairness or otherwise of dismissals within that period, but also because, frankly, we just want recruitment to work. And it's not in our interests to be looking to hire someone and then let them go and have to go through that process once again. So in terms of planning, as I said, we're still waiting for the meat on the bone as far as exactly how this is going to work. But certainly an analysis of what we do around probation and onboarding, and whether we give all of our employees, all of our new recruits, I should say, the best possible chance of success, and that we have a proper process in place to give them the support and the training that they need to make a success of the job is crucially important. I think it also places a highlight on the importance of that recruitment process to begin with as well, and that we do make sure that we are following a robust process to make sure that the person that we hire in the first place is the right person for that role. So in addition to the rules around unfair dismissal changing, we've also seen some other proposals as well, and some day one proposals. Now, the right to make a request to work flexibly is already a day one right, but actually Labour want to go slightly further than that. And they want to not just have all employees have the ability to make a request for flexible working, but they've also suggested that this is going to be the default position for employees. So rather than the burden being upon an employee to make a request for flexible working and the employer then having the opportunity to reject it on the statutory grounds that are set out in the legislation as to why it can't be accommodated. Instead, there's going to be a higher burden on the employer, a suggestion that there's an expectation that employees should be able to work flexibly, and it's up to the employer to set out a positive case as to why that can't be. That would indicate perhaps an end to those statutory grounds that I referred to a moment ago, but exactly how this might operate remains to be seen. I think it's interesting that this proposal is being made at this time because we're seeing a lot of mood music around I suppose, a reduction in the amount of flexible working, or at least many businesses moving back from an initial post-pandemic response of allowing potentially a high degree of flexible working from home, to requiring people to be coming into the office on a more frequent basis. This week even, we've seen Amazon changing their policy and requiring their employees to come back on a full-time basis. Although, of course, they have identified that that's still subject to employees' rights to make claims or make requests for flexible working. So it's interesting that at a time we're perhaps seeing people returning to the office, that Labour is proposing to make that a more viable option for individuals to pursue. We've also seen another piece of legislation that was that's mooted, and we're looking at April 2024 for this. We have some additional rights as far as people returning from maternity leave are concerned. So we've always had a situation where if an individual is on maternity leave, they have the ability to, if they are in a redundancy situation, to essentially get first choice over alternative roles in an attempt to protect employees on maternity leave from being made redundant. But I think anyone who's spent any time looking into this will know that there are some appalling statistics around retention rates for individuals who take maternity leave and then look to return to the workplace. And so this is noticed as being a bit of a social issue that we do need to address. And so the plans that the new government has in place is to potentially place a moratorium on the dismissal of individuals who are on maternity leave, or for a period of 6 months after they return from maternity leave, so, except in some specific circumstances. So again, we don't know exactly how that is going to work, but it is quite a fundamental change, I think, placing this protection on those returning from maternity leave. We will see what that means as and when the new legislation is introduced. We also have some proposals around parental leave. that's going to be unpaid, but it's going to become a day one right. And also some changes around statutory bereavement leave as well, a new right for that, although whether that's going to be paid or not, again, we don't have detail on that. There's a suggestion that statutory carers leave could also become a statutory paid leave too. So lots of proposals there that hopefully we will get some more detail about in the next few weeks. We'd like to see changes in national minimum wage as well. That could include the removal of the 18 to 20 age band as well. And we're also expecting the Low Pay Commission, its remit to be extended and looking to recommend increases to national minimum wage. What other changes might we see? Well, 0 hours working is and has been a topic that the Labour Party has spoken about both in opposition and since it's come into power. The initial discussions around 0 hours workers was a potential ban on the use of 0 hours contracts. But the Labour Party has listened, I think, to feedback from industry that 0 hours workers or 0 hours contracts are often used in certain sectors, both to the benefit of employees and employers. And in fact, I was at an event yesterday speaking to representatives from the leisure and hospitality sector, and their feedback was very strongly that both it worked for their members, but also the employees wanted it. They did not want to enter into permanent contracts with their employers, and enjoyed and appreciated the flexibility that 0 hours contracts provided. So instead, we have the government changing its line on it slightly and talking about a removal or a banning of exploitative 0 hours contract to in a bid to sort of bid to end one-sided flexibility, where the flexibility is all on the employer and not so much on the employee. Again, exactly what that means and how we need to respond to it, we will see when the legislation is published. But I think an audit now to understand where we use 0 hours contracts, if at all, within our businesses, to understand the need for them, whether they can be replaced by different forms of contract, and also understanding the extent to which those that we engage via these 0 hours contracts actually prefer them and want to use them, would be a valuable use of time. We also see the potential removal of waiting days for statutory sick pay. So again, many of you will be appreciative of the fact that at least as far as statutory sick pay is concerned, there's no obligation to pay for the first few days, and there's some waiting days before that becomes payable. I'm sure many of your organisations pay company sick pay in any event and pay in an enhancement to statutory sick pay. But nonetheless, that is something that is proposed too. We're also looking to see the introduction of a new single enforcement body known as the Fair Works Agency, which is going to have enhanced powers around enforcement of workplace rights. Again, we will wait to see specifically what the detail is around that. We've also seen some discussion around amendments to trade union powers. I alluded earlier to the fact that there was some discussions in the original white paper about the introduction of collective bargaining arrangements in certain sectors to set out a minimum standard of employment terms conditions. We don't have that, it wasn't mentioned in the King's speech, but we have had mentioned in that speech discussions around the removal of unnecessary restrictions on trade union activities. And essentially what we're talking about there is the repeal of the Strikes Minimum Service Level Act, which looked to impose certain restrictions in certain sectors on their ability to strike, and the requirement to ensure that certain minimum service levels are provided even during the course of industrial action. So it's a fairly limited, but we're really looking at the potential removal of some of those reforms that were introduced over the last few years of the Conservative government. The Labour Party has also indicated an intention to look again at the statutory recognition process and the way in which unions may gain recognition in a particular workplace. I think any of you that has had any dealings with recognition in the past will know that it is quite a cumbersome process, and the necessity to go through the CAC if an employer is unwilling to agree to recognition. Again, we will see what the government's proposals specifically are around that. We also have the proposed draft Equality, Race and Disability Bill. I referred to that slightly earlier on. Many of you with more than 250 employees will have, over the last few years, been dealing with the necessity of conducting gender pay gap reporting in April every year, or hopefully just in advance of April every year, and not leaving it quite to the last moment. The government's intention, its commitment, if you like, is to try and make it easier for ethnic minorities and also disabled people to bring equal pay claims, and by requiring or putting in place an obligation for employers over that 250 limit to conduct ethnicity and disability pay gap reporting, may provide detail to enable individuals to pursue such claims. Now, this is quite a complex bill, and the fact that it's been referred to as a draft bill is helpful. That's indicative of the fact that this isn't something that we're going to see introduced very quickly. It's likely to be scrutinised in committee before it's published, and there's going to be quite a lot of consultation around it, I suspect. So it's not something we need to worry about immediately. Having said that, it is a stated intention of the government to bring something into force around that. So if we don't already look at gathering data around ethnicity or those that are disabled, then that's perhaps something that we need to be thinking about. But I recognise there are challenges in that. So, for example, many people with disabilities would not necessarily recognise themselves as being disabled. So, for example, someone with a form of diabetes, for example, the test for disability, of course, is whether someone would be very poorly and unwell if they did not take the medication to which they were prescribed. If they continue to take their medication, they may be entirely fine. So they might not perceive themselves as being disabled, but they would fall within the definition of having a disability. But would we anticipate that there would be any pay discrepancy, especially if an employer is completely unaware that an individual has that disability, for example? So there are some challenges around gathering that data. Similarly, around ethnicity, using a purely anecdotal example, my two children, who are both mixed race, my son is quite identifiably and clearly mixed race, whereas my daughter is not. But would I anticipate that an employer would necessarily recognise their race? How would they define themselves too? And also, would I anticipate that if my children both have the same job, working for the same employer, that one of them would be paid less or more because one of them was perceived to be mixed race and the other one was not? I think there's certainly some challenges there, but nonetheless, we have to recognise that the government has an intention to look to introduce legislation around this. So we need to be mindful of what we do as far as our recording is concerned and the data that we hold. The right to disconnect as well. So this is another thing on the government shopping list. They want to give, and we've got the quote up there, the opportunity to have constructive conversations and work together on both bespoke workplace policies or contractual terms that benefit both parties. Now, this is to a certain extent a sigh of relief. We know that many European jurisdictions and indeed jurisdictions across the world have looked to introduce rules around giving the ability for employees to disconnect. And I've got to say, broadly speaking, I approve of the principle. I think it's very important for people to take leave, to have downtime, to not be slaves to their mobile phones and not be answerable at all times. People need to have some time off and some ability to unwind. Having said that, of course, in many organisations, there is a necessity to be responsive and to deal with things quickly. If we're dealing with businesses in different time zones as well, also those who operate 24/7, it's a more challenging thing for an employer to manage if the government is looking to introduce some sort of restrictions on the ability to communicate with staff outside of what would normally be seen as working hours. So that's why it is, I think, a sigh of relief that we're not seeing some sort of mandated, you are no longer allowed to contact your employees outside of their working hours, but instead this emphasis on employers having this constructive conversation with their employees to work together to create these bespoke practices and policies that work for their particular business and that are effective for them, rather than there being something mandated from on high that's supposed to fit for everybody. What we haven't seen as yet are any proposed changes around redundancy, and specifically consultation processes in redundancy. Similarly, 2P as well. 2P is clearly something that derives from European legislation. It derives from the Acquired Rights Directive. And therefore, it is not something that we are therefore obliged to continue to recognise in its existing format. What we will not see, of course, is the removal of Acquired Rights Directive type protections, but there may be scope to amend or look again at the rules around it. Excuse me, especially around consultation. There's nothing announced as yet, but it was something that has been mooted in advance of the government taking power. So we may see some changes in consultation rules. Similarly, we saw the government in its manifesto and also in the white paper talking about the potential ends to the status of workers. So bringing in a single employment status. So again, you are either an employee or you are self-employed. That would then remove that strange third definition of worker who is entitled to some rights, such as the right to annual leave and the rights under the working time regulations, and also the rights around national minimum wage, but not having protection from unfair dismissal. This would be quite a substantial and significant change to the way that we engage employees across sectors in the UK. And therefore, there will need to be some significant thought given as to how that might be introduced. It's worth remembering that, again, our slightly strange situation of having having three definitions of a worker in the UK is unusual. Most employers, European countries do not have that. Most of them will have either employee or self-employed. So that would be moving us towards a more orthodox approach. But I do recognise that because so many businesses do have those three tiers of individuals perhaps engage with them, it will represent quite a significant change. So we do need to wait and see whether the government does indeed introduce proposals in that regard. And if there is a consultation, I'd certainly encourage everyone, if you do have an interest in that, to engage with that consultation process and share your views. So summing up then, what do we know? Well, we know that there are going to be some substantial changes in the next 12 months. Unfortunately, what we do not know at this time is all of the details around what those changes might look like, but we can anticipate that within the next few weeks that we will find out a bit more. Certainly, we'll be making sure that on all of our social media channels and also through updates to our clients and mailing groups that we will keep everyone abreast of those proposals as and when they are published. We do, however, anticipate that there is going to be a step change in the way that employment law is operated in the UK, and we are going to have to address that and come to terms with it. So we do need to be engaging with our HR teams now to make sure that we do have appropriate and updated policies. We do need to think about where some training may be required, especially around those issues of sexual harassment, where we have that new positive duty being introduced, and also around probation. As I said, exactly what that carve-out is going to look like in terms of unfair dismissal, we wait to see, but I really would encourage everyone to make sure that we're looking at introducing robust and fair probationary processes to give ourselves every opportunity to be successful in those recruitment exercises that we conduct, and to be prepared to look at our policies to make sure that they are fit for the new landscape that we are potentially facing. So that's essentially it from me for now in terms of the presentation is concerned. I can see there are some questions in the chat box that have come in. Just dealing with a couple of them, I've seen that Amy has asked about the size of employer and sector and working environment with this new law applied to regarding the sexual harassment laws. It's everybody. Okay, so there is an obligation upon all employers to take reasonable steps to ensure take the preventative steps to ensure that sexual harassment does not take place in that particular working environment. What those reasonable steps might be will vary from sector to sector and employer to employer. What might be necessary and deemed reasonable for a much larger employer might be seen as excessive and overkill for a smaller employer. So it is a question of looking at what your particular business looks like, its size, its resources, where you identify some risk areas, the sort of, are you, for example, a business where you have lone workers? Are you a business where you are a service provider and you have small teams that go and work in a different working environment? Are most of your people working in the office? You need to consider all of these issues and understand where you think your risk areas might be, and decide in those circumstances, what do we think is the best way of communicating these obligations to staff and ensuring it doesn't happen. Another one from Amy as well around what do you think about employee right to request a 4-day compressed working week at day one? Will this be default and therefore should be granted unless there's a good business reason why it would not work for the employer? Well, we wait to see what the legislation says around the added burden on the employer. As I said, at the moment, we currently have some statutory grounds upon which we can rely to turn down a flexible working request, which even as the law stands at the moment, it can be made at day one. We know that the Labour government is keener on the 4-day working week, for example, than the Conservative government. We know that the former government, for example, threatened some councils who were looking to introduce a trial with funding implications if they went through on that with their proposals. Versus there is another trial, I think, due to start imminently involving another raft of employers that are taking the plunge and giving this a go. So I think we can anticipate the Labour government is more accepting and more pro flexible working or varied working rights. Exactly how that's going to manifest itself in the legislation that we see, I think, potentially remains to be seen. But as a general rule, as things currently stand, it's about looking at what you can accommodate within your business. If someone is saying to you, well, I want to work 4-day compressed week right from the outset, but actually you need coverage in the role that individual takes across the full 5 days, then that's not something that you can potentially accommodate because you need someone to do that work over the full 5 days. Whereas in other circumstances, it may be something that you can accommodate. Seen something, another question here as well, but would it be okay to give a deadline for acceptance for the new terms, conditions, and if the deadline passes to process the leaver? I suspect that's in respect of the fire and rehire process. Then yes, that's generally speaking how it works, that you would give notice to the individual that you are terminating their employment. You would give them an offer to accept the new terms, conditions, and you would say, well, look, there is an expectation that you will need to accept these new terms by a certain date, and if not, you will be processed as a leaver. I think if you had an individual who then asked you the day before the contract was going to expire, actually, I've changed my mind, I would like to now accept that offer, then if you were to say, well, tough, I'm sorry, you've waited too long, then don't forget there's going to be a requirement for any dismissal of that nature to be fair in all of the circumstances, as there would be in respect of any dismissals. So we'd have to ask ourselves, well, would it be fair in those circumstances to say, no, sorry? I could see how it might be a bit of an administrative pain to have to, undo some of your expectations. If you'd hired someone to replace them, for example, then that might be a nod in the direction of that decision being fair. Whereas if you haven't, then why should you not allow that person to change their mind and offer that new role, even if it's quite a late date? So I think it will depend upon the circumstances as to whether that is fair or not. And the last question in my box, I hope it's an easy one because it's from Nick Bailey. I have seen the right to disconnect described as a potential code of conduct, much like the ACAS code, but has there been any indication as to whether it will apply to all employees, or are there roles or industries that are exempt? Good question, Nick, and good to see you're here. We wait to see. As I said, the event that I was at yesterday was actually a leisure and hospitality event, and one of the speakers was actually about to go and discuss with the Chancellor some of the rules. He was leaving our meeting to go and meet up with the Chancellor to talk around some of these issues around the right to disconnect, for example, and also the 0 hours workers. And the discussion was around the government recognising the need to not mandate processes. I suspect there may well be a code of conduct that's issued in much the same way as we're seeing code of conducts issued in other areas as well. But the focus is going to be upon the expectation that an employer will work with its employees to understand what works for them and what doesn't work in certain circumstances. And clearly there may be some roles, some industries where it is very, very difficult to have a process where all employees have that right to disconnect at all times, and it may have to be fettered or amended in some circumstances. I've worked in an environment before on secondment where I was dealing with people in the West Coast of America, and I was also dealing with people in the Middle East, which meant my weekend, on Friday evenings, I was still receiving emails from my contacts on the West Coast because they needed my support, and that was when they were awake and they were doing business. And then I might have some time off on a Saturday afternoon when nothing was coming in, but then on a Sunday, the Middle East was up and working again, and there might be information that was coming through from them. So we have to recognize that we live in a global environment and a global business environment, and we also need to recognize that businesses have to operate, and there may be business critical reasons why that entire obligation to work to switch off might be inappropriate in some circumstances. But hearteningly, to repeat myself, the focus would appear to be on the need for businesses to identify what works best for them, rather than it being mandated specifically as to what all employers should be doing. Okay, I think I've probably talked enough for now. I've certainly taken up my 45 minutes and more that I had with you. I hope that you have found that interesting and useful during the course of this morning. Thanks very much for attending. Just to mark your cards, as I said earlier, this is, of course, one of a series of webinars that we host for in-house lawyers. The next one coming up, I've been asked to remind you of, is on the 28th of November, and that's our annual contract law update. So please do join us if you're able to. A PDF of these slides will be sent out after the event, as well as follow up. All that remains for me this morning is to say thank you very much for joining us. Thank you very much for listening. And if you have any additional follow-up questions, then please don't hesitate to reach out. And thank you all, and goodbye.